back from lunch, everybody? This court shall come to order. Okay, for our afternoon panels, I am thrilled to introduce, briefly, Professor Garrett Epps, a proud alumni of this institution, and also a professor at the University of Baltimore School of Law. Professor Epps, thanks so much for coming.
Thank you, Jennifer, and thanks to all those who organized this conference. It's a great honor for me to be asked to comment on a very fine book by two scholars whose work and teaching I admire very much. I must begin by acknowledging an enormous debt to Professor David Lang. Professor Lang was responsible for many of the most pleasant experiences I had while I was a student here at Duke Law School. I don't refer so much to my attendance at his class in intellectual property, although that was unquestionably a high point in my legal education. For those of you who haven't had that pleasure, Professor Lang's sophisticated lecture style, his frequent allusions to Shakespeare, Ansel Adams, and the Grateful Dead, the depth of his understanding, the inherent fascination of the material, made those twice-weekly classes a treat. But pleasant as they are, those are not my happiest memories of Professor Lang. In order to explain what follows, I have to ask the audience now to picture me as I then was, the wearer of a gray beard. I cut rather a dashing figure as a 38-year-old first-year law student. I was frequently mistaken for an alumnus who had wandered away from his 25th reunion. But I spent a great deal of my free time in the library, and not seldom students that I didn't know, many of them attractive young women, would come up to me and rather shyly ask me complicated questions about the finer points of legal doctrine. I thought at the time that this was a tribute to my general air of sagacity and perhaps a certain man-of-the-world polish I had acquired as a newspaper correspondent. I did notice that many of the questions were about torts. Others were about copyright. It didn't occur to me that there was anything odd about this until much later, when I heard that one of those I had advised had become incensed at Professor Lang over the grade she received on his torts exam. How could he have marked her answers wrong? He personally, in the library, had told her that, yes, a private party could sue another private party for first-degree murder. After that, Professor Lang asked me if I'd mind studying in the stacks. And since a number of my other fellow students had made the same request, I changed my locale. But after that, I had a new understanding of the copyright doctrine of striking similarity. As I look back, I am grateful Professor Lang did not bring an action against me for passing off. I didn't have the good fortune to study with Professor Powell. I have over the years enjoyed his counsel and ideas as a professional model, and during my visit here in 2001-2002 as a colleague. Every year I share with my first-year constitutional law students the insights of his really very important essay, The Original Understanding of Original Intent. I'm currently working on a project about Article 2 of the Constitution, and it's very humbling to work in an area in which Jeff Powell has cast such a long shadow. I occasionally have asked him questions about this topic, and I profited by his answers, even when, as a biblical scholar, he has chosen to answer me in Aramaic or Sumerian. I'm heartened that two such formidable intellects have chosen to tackle the problem of the growing occlusion between free expression values and our country's ever-hardening commitment to rights of private ownership of intellectual property. Professor Lang asked me if I would mind starting my address with the words, "this wonderful book." He asked me also not to refer to Shane, which I hadn't planned to do. This wonderful book provides a clear and coherent summary of contemporary intellectual property doctrine. Reading this part of the book took me back to those happy days at the law school as I scribbled desperately, we still scribbled in class at that time, to try to keep up with Professor Lang's lightning mind. Over the past few weeks, as I read No Law, the authors have cleared up a number of longstanding puzzles and confusions about copyright and trademark. And on this score, I have only one real criticism of the book, and that is that I wish the authors had been gracious enough to have published it before I had to take Professor Lang's exam, on which I received the lowest grade of my law school career. The original research and analysis in the second half of the book elegantly captured a number of the remaining outstanding questions and puzzles of First Amendment law, an area I know a little bit more about. But No Law is more than a summary or a treatise. It attempts to combine the law of intellectual property with what Thomas Emerson called, and what Neil cited earlier, the system of freedom of expression, a system with values and internal logic. Intellectual property and the First Amendment are increasingly coming into collision. Borders between them are being rather haphazardly demarcated. All too often, the collisions are unplanned, the ground of combat poorly selected, the strategies of the two sides ad hoc and piecemeal, and the results ambiguous and threatening. The First Amendment, which to outside observers often seems to be the strongest part of the Bill of Rights, is disturbingly often losing these skirmishes. I've been a fiction writer and a poet as well as a legal scholar, and I find the drift of current legal doctrine in this area troubling. Professor Lang notes in his essay, At Play in the Fields of the Word, that a kind of exuberant appropriation is the very foundation of that elusive quality that we recognize as artistic creation. Words are made of other words, stories of other stories, images of other images, songs of other songs. In fact, much of this talk is made of words that I first heard Professor Lang say, and I make no claim of originality for what follows. It might perhaps be charitably called Variations on a Theme by Lang and Powell. The very foundation of the Western literary tradition, its inexhaustible source, is two long poems. Their reduction to writing nearly 3,000 years ago was an audacious act of literary appropriation. Many years ago, I had the privilege of studying with and knowing the late A.B. Lord, author of The Singer of Tales, which is still the premier work on the composition of the Iliad and the Odyssey. And I remember the uncanny feeling, a feeling that Vladimir Nabokov once called the crackle up the spine, as I heard Lord tell how, as a young man, he had carried a primitive wire recorder into a coffee house in what was then Yugoslavia, and heard a storyteller reciting in Serbo-Croatian epic stories that apparently flowed in unbroken oral transmission from ancient Greece. The geography of Odysseus' travel home or Achilles' mode of combat had been changed to suit the Balkan setting. The heroes rode horses instead of chariots or wooden ships. But not only the heart of the story, not only the order of the events, but the recurring verbal formulae, such as the rosy-fingered dawn, or when the armies came together at one strategic point, or the men reached out for the good things that lay before them, corresponded closely to that of the stories we attribute today to someone named Homer. These bards were using tropes that Homer had adopted from other bards, going back, scholars think, perhaps as far as the Epic of Gilgamesh. Closer to our own time, Don Quixote, the first real Western novel, represents itself as the work of an Arab author named Cid Hamiti Benengeli, published without authority by Miguel Cervantes de Saavedra from a translation by another Spanish-speaking Arab. But in fact, the work was that of Cervantes, and it was itself the subject of another audacious act of appropriation. The Quixote was published in two parts. In 1615, a decade after Part 1 had been published, Alonso Fernandez de Avellaneda hustled into the bookstores with a book he claimed was Part 2. Cervantes was appalled. Readers acclaimed the spurious sequel as enthusiastically as they had taken to the authentic Part 1. His artistic pride wounded, Cervantes hastened to his desk and wrote the material we now know as the authentic Part 2 of Don Quixote. One of its minor themes, as Nabokov notes in his lectures on Don Quixote, is the insuperable difficulty for any interloper of writing a book as good as the original Part 1. Subsequent events, I think, have proved Cervantes right and established that Fernandez de Avellaneda's infringing work was no real threat to the genuine Quixote. I thought of Cervantes a few years ago when a federal judge in Atlanta, for what I think was the first time in American history, relied on copyright to issue an absolute prior restraint on publication of a novel. This case is discussed ably in No Law, and our own Jennifer Jenkins was present and one of the counsel. I won't spend much time on it. The book was The Wind Done Gone, written by a first-time author, an African-American woman named Alice Ramdell. Clearly a takeoff or sequel to Margaret Mitchell's Gone with the Wind, this time told from the point of view of the black residents of Tara. During oral arguments on the request for an injunction, the district judge, like a character in South Park, apparently exclaimed, "You've killed Miss Scarlet," because the book depicted the death of a Scarlett O'Hara-like character. As might be predicted from this comment, the judge ordered the book permanently enjoined, and in his opinion, his entire consideration of the First Amendment is as follows. The defendant argues that the First Amendment must be the court's chief concern. With respect to copyright protection, however, the First Amendment does not license an infringing author to trample on legally recognized rights. In other words, during this battle between the domain of intellectual property and that of intellectual freedom, the First Amendment managed to get precisely 35 words in edgewise, while copyright received more than 13,000. Fortunately, the Court of Appeals vacated the injunction. But the case did make me think that if Cervantes were living today, he would have responded to Fernandez de Avellaneda not by reaching for his quill, but by calling his lawyers at the firm of Panza and Del Toboso. The complaint they would have filed would itself be a literary masterpiece, but probably not a replacement for Part 2 of the Quixote. It's equally possible, of course, that Avellaneda's infringing book might have been published shortly after Cervantes signed a lucrative contract granting film rights to the Disney Corporation. In that case, Disney would have carried on the lawsuit, and instead of Part 2, world literature would be blessed with direct-to-video films with titles like Chihuahua of La Mancha. I don't want to be tendentious.
You lie. It just comes to
Quite seriously, thanks for sharing that. As a writer myself and a member of a four-generation literary family, I would never undervalue the legitimacy of an author's desire not only for recognition of her work, but also for payment. We all know Dr. Johnson's words about blockheads. And I recall vividly my own great aunt, who in her time had been a very distinguished children's author, but who learned in her old age that no one had applied for extension of copyright on her books, and who turned her face to the wall and soon died in large part of grief. But I do think it's worth asking why it is that questions of ownership and originality have come so insistently to the fore at this point in our history. While I was still in law school, news reports first circulated that the late Dr. Martin Luther King Jr. had apparently intentionally lifted significant parts of other writers' work into his own doctoral dissertation at Boston University. And the New York Times, in reporting the news, quoted a very fine King scholar, David Garrow, as reacting to the news this way: "This serious an offense really does alter how we have to evaluate him, especially in the context of telling 10-year-olds who they should look up to." Is this really so? I recall saying to my children when they were young that King had bravely led the Montgomery bus boycott, that he had eloquently given voice to the hopes not only of black Americans, but of all those around the world who long for equality and freedom, that he had looked death in the face and walked straight toward it because he believed that was the path of justice. I was remiss. I did not ever caution them that he should not be admired because he was a sloppy or deceitful preparer of footnotes. Why in heaven's name has plagiarism in contemporary America come to seem to be an offense on a moral par with murder or child molestation? Why are lawyers leading this charge? Lawyers, by tradition, are the most aggressive plagiarists of all. Much of the writing done in law practice is composed of pre-existing formulas, as surely as were the Serbo-Croatian epics recorded by A.B. Lord. When was the last time, you suppose, a partner called in a junior associate and fired him or her because of striking similarities between a complaint the associate had written and one written in an earlier case by another member of the firm? Where have we as lawyers acquired this pharisaical zeal for sniffing out appropriation by others to the point that a federal judge can enjoin publication of a book without even noticing the First Amendment, like Richard Petty blasting by a one-pump Crossroads gas station? I don't think it's really coincidental that the idea of intellectual property has begun to harden and congeal at this precise time in our history. The desperation behind contemporary intellectual property doctrine is hinted at in No Law, where the authors write with characteristic wit, "Believing in intellectual property is like believing in Tinkerbell. We clap our hands, and it is so." But the analogy doesn't go quite far enough. In point of fact, most of us understand that no matter how desperately we clap, there are no fairies. We must desperately pretend to believe in Tinkerbell precisely because she doesn't exist. The more indignantly lawyers and governments insist on the solidity of intellectual property rights, the more insistently one should suspect that they know this species of property has no real existence. I'm reminded of a famous quote from baseball pitcher Lefty Gomez, who was asked by a reporter to comment on recent scientific work that suggested the curveball didn't actually curve, but simply deceived batters into thinking that it curved. "Here I am trying to make my comeback," Gomez was said to have said, "and they tell me my best pitch is an optical illusion." I think today in the United States we suspect that we may be an optical illusion. The United States currently remains at the top of the world economic pyramid. But at night, I think most thoughtful Americans worry whether this high altitude is like that of Wile E. Coyote, who has run off the edge of the cliff but hasn't fallen yet simply because he hasn't looked down. What is it that we do in this country that would support our aspirations to remain the richest country in the world? I don't think it's unduly cynical to suggest that our current situation of simultaneous dominance and insecurity is owed to two things. The first is our unmatched military capacity. But we now clearly see the limits of that capacity as our military has been stretched to the point where it may not be able to function successfully anywhere. The other thing that tremulously sustains the American economy is our capacity to manufacture and market not things, but images and sounds and ideas. Films, television shows, musical recordings, computer software, brand logos. All these things are Tinkerbell. Magical and valuable only for those who believe, or who can at least be coerced into clapping their hands. And our efforts at coercion must grow in direct proportion to our dependence on these things for our national survival. I'm sure I'm not the first reader to notice that J.M. Barrie's novel and play, Peter Pan, are an allegory for the centuries-long Western misadventure with colonialism. Peter has run away from the drab world of the metropolis to a magical island inhabited by Indians, pirates, crocodiles, and magical spirits. On this island, he will not only never grow up, he will have magical powers, including most particularly power over women. Not just Tinkerbell, Princess Summer, Fall, Winter, Spring. I mean, the guy is, what's he got that I don't have? It's the world of Britain's Caribbean colonies. It's also the world of Shakespeare's The Tempest, the first literary depiction of English imperialism, with Pan as Prospero and Tinkerbell as Ariel. The Lost Boys are the ghosts of young English soldiers buried in India, Afghanistan, China, and Africa during the days of empire. Lost Boys are the price we in the United States today pay for world dominance. And the prize we seek is a world like Peter's, in which we as a nation are immune to decay and decline, however insistently the clock in the crocodile's stomach may remind us that these enemies lie patiently in wait. The rising imperial claims of intellectual property mirror the fading imperial ambitions of America as a nation. We are ready to defend them to the last lawyer. We may not be able to continue to rule the waves, but we fondly hope that we can rule the airwaves. Galloping imperialism is an apt phrase, but the horse is lame. And once our dominion is gone, we fear we will be left with nothing. History suggests that our hopes are delusive. Far called, our navies melt away. All physical empires, all empires based on force, are temporary and tragic. If our influence is based on coercion, military or legal, it cannot be sustained over time. American films and music will be valuable precisely to the extent that the idea of America is valuable to the world. And that value over time cannot be sustained by force. That value must lie in the merit of the ideas, in the merit of the works that vital culture produces. And artistic merit, as Homer knew, lies in greatness of vision, not in something called originality. In willingness to appropriate and to be appropriated, not in diligent policing of property interests. The value of America must lie in its example as a society that privileges democracy over authority, law over force, openness over ownership. American songs and films are prized today because they represent to people elsewhere the substance of an idea they can make their own, the idea of a society where authority does not oppressively constrain creation, whether that creation be economic, creative, or personal. That idea cannot be copyrighted, trademarked, or patented. And in fact, as the confines of those imaginary realms grow more restrictive, the twinkling light of the idea, like Tinkerbell in Peter Pan, will waver and begin to disappear. And if it does, no amount of clapping will bring it back to life. America today, in intellectual property terms, is like a wealthy family in a third world country, surrounding its property with high fences, razor wire, and broken glass. But the new ideas, the ideas that could sustain us, live outside the wall. The more we insist on owning what is inside, the less we will be able to use what is outside. And eventually, the crowds outside will tear down the walls, and we will be left with nothing. Ideas, images, tropes, even words are viral, or they are not ideas. Whatever we may do to them, we no more own them than Homer owned the rosy-fingered dawn. We may be able to kill them, or more likely to destroy ourselves. But when we release them into the world, they remain valuable to us and to others. One can be in relation to something, can even profit from it without excluding it, owning it, or excluding others from it. I recall in this connection some lines from Rainer Maria Rilke's For Hans Karassa. When something's let go of, it circles, and though we are rarely at the center of the circle, it draws around us its unbroken, marvelous curve. It is better to be one focus of a live curve than the owner of a dead line. Consider the curve that is Barack Obama. The complexity of the Obama idea far outstrips the real content of the person who signifies himself as Barack Obama. Indeed, as Obama has found, Barack Obama does not even own the idea of himself. And in fact, the more I study President Obama, whom I admire, the more I think we may be confronted with a picture of a rather dull policy wonk living inside an interesting symbol. The symbol is no less valuable to him and all of us for the fact that none of us can own it. In that connection, let me note a current controversy in intellectual property without tendentiously drawing a clear moral from it. Thank you very much. So give me a nice paper cut and pour lemon juice in it. The Associated Press is involved in a lawsuit against the artist Shepard Fairey over rights to a poster of then-candidate Obama that Fairey designed. The poster has already become a worldwide icon. Displays an unsmiling but thoughtful Obama gazing upward and into the distance as if lifting up his ideas unto the hills. Underneath the image is the word hope. The AP says that Fairey has illegitimately appropriated a photograph of Obama that one of its photographers, Manny Garcia, took in 2006. And Fairey has responded with a suit seeking declaratory judgment that his use of the original image is protected by fair use. Undeterred by the legal controversy, the image itself, as constructed by Fairey, continues to spread across the globe. Not long ago, reproductions of the Fairey Obama began to appear on walls and traffic signs in Boston. And in February, when Shepard Fairey came to Boston to attend a retrospective exhibit of his work, the Boston police intercepted him, placed him in handcuffs, and put him in jail overnight on charges of defacing public property. Lest we unduly schematize this as a morality tale, let me note that Fairey, meanwhile, has sent a cease and desist letter to a menacing infringer who has made a profit of $70 selling Pittsburgh Steeler Kewpie dolls that use the slogan, "Obey Steeler Baby." Fairey's lawyers have now publicly asserted that he owns the commercial rights to use of the word obey. A rebel artist now writes the idea of obedience. Was ever a richer crop of tea ready for throwing into Boston Harbor? The level of societal self-hypnosis embodied in this legal feeding frenzy is an ominous sign for the survival of America as an idea. And perhaps worse than that, its fatuity is aesthetically repellent. But I would like to conclude by saying that whatever others may think, I myself still believe in fairies. Would you kindly clap your hands?
Thank you, Professor Epps. Our next speaker is Professor Keith Aoki from the UC Davis School of Law. Professor Boyle and I have worked with Keith on a comic book and another one, and I have to say Keith is one of my favorite people, and an incredibly talented comic book artist in addition to being an intellectual property law professor. I think he's going to talk to us about it.
Well, I was going to say, I'm going to paraphrase Monty Python, and instead of saying now for something completely different, I'm going to say, and now for something that's completely non-substantive. So in some ways, I guess I was invited, hopefully, to help lighten up the proceedings, but I was going to say Garrett is a very, very hard act to follow. So first, what I'm going to do is sing the praises of Jeff Powell and David Lang. I endorse everything that everybody has said. There's nothing left for me to say that hasn't been already said before. I'm going to actually just raise the issue of law and how it relates to no law, and in some ways as developed by scholars like Jamie Boyle or Larry Lessig. And then I'm going to ask a question that's kind of phenomenological that says, how do we know what we know, or how do I know what I know? And then I'm going to end with a shameless plug. So law and no law. In some ways, I guess I got to know Jamie and David in the early 1990s when Jamie was engaged in the critique of the Romantic author along with Peter Yazzie, and I really benefited from their work in the area. In some ways, what they did was introduce me to postmodernism, or the postmodern subject, where the subject's decentered, the human subject is seen as amorphous and indeterminate, and in some ways that the Romantic author was a construct made in some ways to kind of mask some of that instability. Some of the techniques that artists and critics were using over the past, say, 50 or 40 years in terms of developing the postmodern kind of critique were the technique of bricolage, which is in some ways you're finding something and putting it to new uses that for which the things weren't intended. In some ways, you might think of postmodernists as minor birds looking for shiny pieces of metal to rearrange, or intellectual tools like pastiche, homage, or quotation, and in terms of making something new out of that which already existed, but in some ways in a new context. And I'd say another aspect that both David and Jamie have been really wonderful teachers to me about has been the, in some ways, the kind of critique of essential or anti-essentialism, which I think is also part of the kind of postmodern critique that Jamie and David have engaged in one way or another. Okay, well, how does postmodernism, when it intersects with intellectual property, which is the 1976 Copyright Act, and the kind of subsequent case law that has arisen around it? And in some ways, I say in the 1990s, you began to see the kind of political critique emerge of heightened intellectual property laws, of which Jamie and David were definitely at the forefront. And what I was going to say was, where I'm coming from today is not as a law professor, but as somebody who spent a lot of my early years doing things like reading comic books and playing in garage bands. So I come to you as more of a purveyor of popular culture. And I would put it to you that there's something in David's work that I think is interesting. And here I call it the quantum aspect of it, where he's able to look at intellectual property and see them in a couple different lights. One as a commercial marketplace commodity, but also as simultaneously as a meaning-imbued cultural kind of creation or vessel for culture. And I think David and Jamie's work has been very important in highlighting how popular culture intersects, sometimes uncomfortably, with intellectual property. So one thing I was going to say is here's an ideogram that stands for Sensei. And I was going to say, not to be confused with Sensei. Sensei is what I am. I'm a third-generation Japanese-American. But Sensei is a teacher. And I asked my mother one time what Sensei meant. And she said, she thrust around, she says, there's not really an equivalent in the English language for Sensei. You could say teacher. But in some ways, I'd say that probably the closest equivalent you could come to a Sensei is like a Jedi Knight. So in some ways, I salute both Jefferson and David as superb senseis in terms of in the finest light in terms of wielding their lightsabers of intellectual acuity and excellent writing in their book No Law. Also, I was going to say that no law has an aspect that reminds me of a parallel universe or alternate universe science fiction. These are two books that I read when I was younger. One's called Bring the Jubilee, which was a picture of the United States had the South won the Civil War. Another was a Hugo Award-winning novel by Philip K. Dick called The Man in the High Castle, which depicts the United States, as you can see on that map, where the Japanese had taken over the West Coast up to the Rocky Mountains, and the Germans had occupied everything east of the Rocky Mountains. But in some ways, no law is an invitation to contemplate what an alternate universe look like with a robust, in a sense, Hugo Blackian vision of the First Amendment. So I think of it as, in some ways as a parallel universe and tantalizing. As I mentioned, quantum physics, I was going to say that one of the things that David Lang at the beginning of my career was very generous at introducing me to was the Grateful Dead. And in some ways, I think the Grateful Dead embody what I mean about quantum, the quantum aspect of David's thought. Quantum physics in the early part of the 20th century was debating, is light a wave or a particle? And so some people say, it's a wave. And other people say, no, it's a particle. And the actual answer was, it's both. And in some ways, I think David's work, particularly the Grateful Dead, are an excellent illustration of the ways that you can have something be a cultural vessel of meaning. At the same time, it could be a commodity. The Grateful Dead are also interesting because they never pushed vinyl. They were never really that large selling a rock band, but people paid top dollar before Jerry Garcia died in 1995 to see them in some ways because they were the only people who could deliver what they delivered. If you wanted to be part of this anarcho-psychedelic kind of fin de siècle kind of a tribal experience, you had to go to the Grateful Dead concert. Going down to the local bar or even buying a record wasn't that experience. And in some ways, I say this ties into one of Garrett's points, is that in some ways the Grateful Dead actually have a lot to do with lawyers, because lawyers aren't into selling paper or charging by the word. In some ways, you go to a lawyer, in a sense, to have the skill and the kind of understanding of that only they can uniquely deliver. So in some ways, I'd say, David, thank you for the kind of insight in terms of the quantum nature of the Grateful Dead's music and its kind of simultaneous existence as intellectual property. And the Dead also allowed their fans to come in and plug into the mixing board so that in some ways they weren't into cornering the market in terms of pushing vinyl. So with that kind of lengthy introduction, I want to just give you a little bit of insight from my own experience as a cartoonist. One of my, I can say, this is the last thing I was going to mention, was David also introduced me in 1994 to an article to John Perry Barlow, and this is my segue. John Perry Barlow, who's a lyricist for the Grateful Dead, he's also probably the only Republican Wyoming chairperson to kind of drop acid with Jerry Garcia. But he wrote an article called "Everything You Know About Intellectual Property is Wrong," which was published, I think, in 1994 in Wired. So once again, I was going to say another thank you and another link to the Grateful Dead. This is a picture of Art Spiegelman, who's a former teacher of mine. In prior life, about 3 careers ago, I was an artist living in New York, and I took a class from Spiegelman at the School of Visual Arts. And he's quoted in 2006 as saying, "Everything I learned from comics." So in some ways, I'm citing a citation. He said, "I learned about sex contemplating Betty and Veronica, but I learned feminism from little Lulu. I learned about economics from Donald Duck and Uncle Scrooge, politics from Pogo, We Have Met the Enemy and He Is Us." And in some ways, I feel sad because this really dates me, because many people who were born after Walt Kelly stopped doing Pogo probably don't even know who Walt Kelly is. But I would say that's one of his most famous sayings, "We have met the enemy and he is us." Philosophy from Peanuts, and everything else from Mad Magazine. And in some ways, I think this is developing a little bit on David's work, but I was going to say that one of the understandings that when I do a copyright class, that I try to impart to students, is I say there's kind of pre-Mad Magazine and there's post-Mad Magazine in terms of where judges' heads are at. Judges who are post-Mad Magazine in some ways get it. They can get that there's going to be appropriation, recoding, recontextualization. And in some ways, that's what I think Spiegelman's alluding to. Pre-Mad Magazine is like, that's not funny. You're taking somebody's property. And in some ways, I say Mad Magazine begat National Lampoon begat Saturday Night Live. And in some ways, a whole generation grew up understanding that life and entertainment is in some ways a pastiche, or it's in some ways a vehicle or a medium with which to reorganize and kind of regenerate meaning. So what I was going to say was, with that kind of kudos, thanks, etc. to Jeff and David, what I want to do is give you just a cover shot of the book that I did with Jamie and Jennifer, which is Bound by Law. Took a long time to do. It was hand-drawn on Bristol board and ink, so it's like definitely making comics the old-fashioned way. But I was going to say that it's gone into its second edition. But what I'm going to do right now is basically make a shameless plug. These are some drafts of a cover that of our current work that actually we'll be talking about tomorrow. We're planning it out, but it's called Theft, A History of Music. I was going to say this one was rejected by Jamie and Jennifer for the somewhat Fey-like kind of amplifier jack that's kind of being wielded by the leather-clad vixen on the cover. So that one was an unsuccessful draft. Here's another draft of a pencil cover for we're trying to, one of the tropes we use in this is the idea of time travel. So it goes back in time to, say, ancient Greece and moves up in time to go up to the present and then into the future. Kind of rejected that because it's like, in some ways, what's a clock face doing flying through the air? This is where we're getting a little bit closer, but you can kind of see the kind of idea that there's like a zombie who's like basically a copyright zombie in some ways, out to I guess capture, destroy, take control of music. This is another one that we rejected, where it looked a little bit too much like a kind of department store window. And so it has a little bit of the zombie, but in some ways it looks more like they're dancing rather than attacking. And here, I guess, is a shameless plug. This is the final cover that we've worked on. We have about 50 pages done of it. Hopefully, we're going to be able to plot out the remaining 40 or so 40 or 50 pages over the next couple days, and hopefully, we'll have this out and to the printers by sometime in the midsummer. So I was going to say, it's coming to a bookstore near you. And with that, I was just going to say, thank you, David. Thank you, Jeff. Your book is terrific. I really was grateful to have the privilege to review it when I was asked by Sarah Ives of Stanford University Press. I'm very pleased to see it out on the bookstand. So thank you.
I want to note to begin that the girl with the whip seems to be a sort of motif in all the covers. Yeah? Okay. I'm just saying, you know.
We had noticed that too.
Yes.
Not contentious.
Not that it's a bad thing.
So, Garrett, that was a wonderful presentation. And in fact, there's a novelist who I'm advising about a book of collage and subversive quotation, which he just written for a major publisher, except they've now decided this is really wonderful, so long as there's a footnote to every single thing that you take and individualized licenses for each. So they obviously understood appropriation slightly differently than he did, so I've just recommended that he come and watch your presentation. But my question is, there's the you that talks about the nature of appropriation and reappropriation in literature. And there's the you that has really agonized over the true meaning and tradition of the 14th Amendment. And when you write about the 14th Amendment, there are very strong resonances in what you say to your idea of the best hopes, the best visions, the better angels of our nature in the United States, and that's very consistent with what you say. But there is also a sense of there was a meaning of the 14th Amendment, and we have fallen away from it. There was a meaning of the Declaration of Independence, and we have fallen away from it. And that, to some extent, is an idea, even if not of authorial control, some idea of a continuing meaning that goes forward with the text that is connected to the creative nature of the person who put it forward. In your own constitutional scholarship, how do you reconcile those two ideas?
Well, first of all, thanks. Speaking of shameless plugs, the book is Democracy Reborn, still available at obscure bookstores near you, often with the original cover. I don't think the idea is really occlude, because I'm actually, in my narrative of the 14th Amendment, I'm not presenting it to the reader as something that has an original meaning that is accessible to us, and that we have simply wrongly deciphered. I do think there is a difference. There is a difference. You know, one may not be able to point to the dividing line, but there is a difference between exegesis and eisegesis. And much of what the courts in particular have done with the 14th Amendment seems to me to be eisegetical rather than exegetical. But I believe that my critique of most of what we as a culture and a society have done with the 14th Amendment is not that we have inadequately preserved it, but that we have inadequately transformed it. The 14th Amendment, it is presented in kind of oracular language, I think precisely presenting itself to us as something that we should transform, and that to transform it into a footnote to the Constitution or even a dead letter, which courts have done more often than they have not, I think is clearly the wrong answer. That doesn't mean that I think there's a right answer. And, you know, this is particularly relevant right now as originalism is now debated and sort of seized upon by progressives in the wake of Heller versus District of Columbia, with the idea that we're now going to go out and you know, bludgeon judges with the original meaning of the 14th Amendment, and that will mean all kinds of excellent progressive results. I think that is probably, that apple is probably poisoned from the point of view of values that we cherish in constitutional law, and that the correct thing to say, as I've said elsewhere, is that constitutional provisions may have been intended, but in the present they mean, and our task is to not to decipher in a sort of cryptological sense that meaning, but to participate in it and transform it in a way that's constructive. So, you know, I myself find, after sober reflection on your remarks, that in fact I agree with myself, and that I don't entirely see a contradiction, but I'm constantly being accused of being an originalist. And finally, at one talk at a law school, I was just so beleaguered by these that I came up with an alternative name for myself, which is really important in legal scholarship. And I said, I'm not an originalist. I'm a situationalist, meaning that it is relevant to know the situation from which something was produced, and I do think that's relevant. And then I thanked the hostile audience by saying I came out here some schmuck with a law review article, and I'm going back as a school of thought. So I'm glad I got to plug that in response to your question.
More questions? Michael.
Professor Aoki, you mentioned that there's sort of like a pre-Mad Magazine judge and a post-Mad Magazine judge. Do you think that, like, as far as the development of fair use goes, do you think there's going to be, do you think that actually means that there would be like a widening of the protection for things like parody and satire? Whereas, despite the fact that that if anything, I guess the theme of this discussion is that intellectual property rights are getting narrower, and there's more, you know, there's more control over smaller bits. Do you think that in the realm of making fun of something, it's going to widen, whereas in other realms like education, it'll narrow, and news gathering?
Well, a couple things. I don't really mean to say that suggest there's a divide. Say, Mad Magazine began publishing in the 1950s, but more in terms of its narrative. So, for example, Judge Cardamone wrote the opinion of Rogers v. Kuhn. I would definitely say it's a pre-Mad Magazine type of jurist who basically doesn't get what's going on. I'd say the 11th Circuit, which in some ways wrote the When Done Gone case, reflects a judge who does get it, that there could be something that you're doing with pre-existing materials that's also a comment on it. And I say to an extent, Souter in the Two Live Crew case would also, I'd say, at least begin to get it. But then there's also anomalies, like say the Cat in the Hat kind of case where in some ways using the Cat in the Hat as a vehicle to parody what's going on in the OJ trial was, like, say, not a fair use. what do I think in terms of the kind of increasing scope of intellectual property kinds of claims? I think that they're definitely in tension with that kind of postmodern idea of pastiche and homage and kind of overlapping and in some ways recoding. I'd say it's kind of an idea that there's really nothing new under the sun, but it's just like Garrett said, it's in some ways the kind of situation that something comes out of that will change, and then in some ways gives rise to a new set of meanings. The last thing I did forget to say, okay, garage bands and comic books, that in some ways they exist as intellectual properties. Clearly the songs are copyrighted and copyrighted art, like say Superman. But on another level, it's like when I was learning how to draw comic books, it's basically I would take a comic book and I'd copy it exactly as I could. When I was learning how to play guitar, I would like listen to say Eric Clapton on Sunshine of Your Love, and I'd listen to it like 100 times until I got it. And so in some ways I was going to say that that's quantum. It's you can have intellectual property and something be a commodity, but at the same time it's susceptible to say learning or copying something as a vehicle to understand it. One of the things that I've learned in terms of just being an artist is it's maybe taking a page from Leonardo da Vinci, and I'm definitely not in Leonardo's league, but he used drawing as a way of understanding the world. So a lot of times I did a parody one time of the Beatles' Abbey Road cover for Rock Band I was in terms of a poster, but when you try to copy a cover of something like Abbey Road, you really understand how good the photographer was who took the picture in terms of the composition. And I'd say this is something that even Beaux Arts, in terms of the French academic art tradition, they encourage people to copy sculptures, copy paintings as closely as possible in order to kind of understand what's going on in them. So I was going to say that's why I would say that at least for me, comics and garage bands were two vehicles where copying was the way I learned how to do them.
Questions? Okay, let's thank our panelists. Thank you very much.
Think of anything to ask for. I think it's more like it's late in the afternoon.